the entire situation in River State is still a mystery to some people and not to some others. Relying on Section 188(26), lawmakers signed a notice of gross misconduct. They accused the governor of budget violations, illegal spending without assembly approval, institutional sabotage, including the 2023 demolition of the assembly complex and swearing in of 19 commissioners and an attorney general while bypassing protocol, ignoring Supreme Court rulings on financial autonomy. He is also accused of withholding salaries of lawmakers and the assembly clerk. With the speaker ordering the notice to be served within 7 days, the state is heading to a major constitutional test. Well, the notice has now been served, and they have vowed to go ahead with that impeachment. What exactly is going on? I'm being joined in the studio by Vincent Otaopupu, a legal practitioner. Thank you for joining us, Vincent.
Thank you for having me.
So let's start from what some would say is the funny side. In the first and second round, my colleague was talking about of this impeachment exercise. The two parties, the governor and the legislators, were in one party. In this third attempt, the governor and the legislators are in another party, the same party, incidentally, except the principal, who seems to be on his own.
On his own, partyless.
So what's going on, in your opinion?
It's quite, what is playing out in Rivers State is quite unfortunate, which may, if not properly checked, could pave way to a catastrophic consequences of an unpredictable dimension, and which will be bad for everybody. That need to call the lawmakers to order. For the first time in comparatively recently, we have a legislature belonging to a political party and the governor in the same political party. And the legislators are moving all angles to remove a member of their political party. It is quite interesting. But beyond this point, what is happening in Rivers State calls for a sober reflection, in the sense that there is a departure from the duty imposed on the legislatures by the Constitution and by the people of Rivers State in the social contract theory, which they executed and signed by the people when they were elected. What has happened today is the devastation of the mandate of the people. It's an abandonment of the mandate of the people, which we say ex abandonta siticuta. They are not empowered to abandon their legislative duties, which is principally to see law as an instrument of social development, law as an instrument of peace and harmony, law as an instrument of social engineering, that the end of lawmaking must be to touch the life of the people, protect the lives of the people, as the case may be. Now the governor has been devastated. The governor has put in a political quagmire, political gerrymandering, to the point that he cannot even perform all about, doing executive functions. Constitutionally started on him, but moving around on how to secure his seat. It is quite unfortunate.
We also have joining us Dr. Sam Amadi, Executive Director, Abuja School of Social and Political Thought. Dr. Amadi, this conversation is not the first time you're having this kind of conversation. But in the realm of politics, in the realm of political thought, some will say that after that emergency situation that was in Rivers State, all of these matters that the governor is being accused of had been taken care of in terms of budget presentation, illegal budget, or disobeying the Supreme Court, or even withholding salaries. There's even news or, information coming in that they were actually paid by the interim administration all their allowances and salaries within that period they were suspended before Governor Siminalayi Fubara resumed. But where are we now?
Well, thank you for having me. First is that impeachment is designed as constitutionally as a tool of political accountability. So the idea of giving legislatures the power to initiate and complete impeachment of office holders is a form of political accountability, and it's premised on the notion that political problems have political solution. So if, for example, it's possible that a governor, elected official, governor, deputy governor, could, so obviously and evidently, related to his oath of office, misgoverned. The Constitution gives the legislature the discretion to decide when to trigger impeachment. But the good thing is that because it's a tool of accountability, the same Constitution provides a check. The Nigerian system is superior to the US system. The US system, all the processes are political, which means the House, if it's for the President of America, the House of Reps convict you and impeach you, the Senate remove you. But in Nigeria, it involves three branches, it involves two branches. So the legislature starts, then the court weighs in. And that's a saving grace, which means, even though in my view, I think there's perhaps no real gross misconduct in the classical sense existing now since the return of Fubara and the legislators. Maybe issues around not funding the legislature, if they are well established and gross, then that could pass. Or we've not seen clear case of constitutional infringement. So it's political, and the political solution is going to happen. So they're going to court. They've got it. My worry is that again, like the French philosopher Tocqueville said about the democracy in America in his book. He says no sooner than political crisis become legal crisis. So it's ending up now to become a legal crisis. There's a court order. Maybe it will be another court to issue a different order, and they end up not just that they misdirect the governor, they constrain effective executive use of executive time, they entrench intolerance, and there's a showmanship and brinkmanship that pushes the political system to a level of politicizing judiciary and judicializing politics.
Okay.
So the tool, that's political tool, will not turn into a judicial tool, and the court itself will become a political battlefield. So that's really the tragedy in this case. But I guess this will fail as well.
Okay, Dr. Amadi, we'll take a moment, and Vincent, we'll take a moment. We'll go on a quick break. We'll come back and look at, is there a puppeteer somewhere who is pulling strings back and forth? But that'll be when we come back from this break. Welcome back. Now, we still have Vincent Otakupu, a legal practitioner, here in the studio with us, and joining us virtually, we have Dr. Sam Amadi, Executive Director, Abuja School of Social and Political Thought. Thank you for joining us, gentlemen. Vincent, before we went on that break, Dr. Amadi talked about a legal solution. Now there's a court injunction, the legal solution to this political quagmire that you mentioned earlier. But would that really work? Because it appears as a puppeteer somewhere who's pulling strings.
So thank you for that question. First of all, I agree with my learned brother, Dr. Sam Amadi, that the impeachment is an effective instrument for check and balances in a constitutional democracy. And you know that impeachment, as a principle of constitutional law, have received a legislative imprimatur under Section 188 of the Constitution. And Section 188, sub 1 to 9, provided a conditio sine qua non, which must be followed, a strict requirement of law which must be followed for effective exercise of a legislative process of removing a governor or deputy governor, and that must be followed. And it starts with the one-third signing of members of the House, signing a petition of complaint presented to the House. And what is done, there's a resolution adopting that, and for 7 days, it will be sent to the governor or deputy for their response, which they must do within 14 days. And if the response is sent back, then there's a resolution of two-thirds adopting it and calling for CJ to reach out to this the speaker to reach out to the CJ to constitute a 7-man panel to look into it. And they have 3 months to look into it, and the fellow must be invited to be given fair hearing to respond to allegations. And if that is done, the panel will send their report back to the House, and the report must be proved, allegation proved or allegation not proved. If they say allegation not proved, that is the end of the matter. But if they say allegation is proved, the House will now, by the third majority, adopt that result, and they adopt the report, and the fellow stands removed from office. These are processes that the Supreme Court have heard in litany and cornucopia of cases that it must be followed. Before now, Section 188, sub 10, have ousted jurisdiction of the court and said no proceedings with respect to impeachment of governor, of deputy governor, or president of and vice president under Section 143 of the Constitution can be, or even a committee appointed for that purpose, can be entertained by any court of law in Nigeria. So the court jurisdiction has been ousted. Supreme Court have interpreted these cases the locus casus case of Akintola versus Ademboro, which is, a 1963 case, when there was a... So, up to the case of Abaribe versus Abia State House of Assembly. I'm coming. Now,
there's no time.
No, so that is that. But recently, Supreme Court have held in Ilokoju versus Oyo State House of Assembly, that's a delicate case, with respect to Governor Ladoja, that you must follow the procedure. If you fail to follow it,
in this
it
case
will be struck
now,
down. In this case, the court has given injunction. One, there are two cases pending in court. One filed by Fubara, one filed by Ngozi Nma-Odu at the State High Court, and there is two order now, interim order, restraining the 32nd defendant, which is the CJ of Rivers State, from dealing with the subject matter of impeachment whatsoever until the matter is determined. So CJ, as a law-abiding citizen, all the House members and Speaker are parties, but the order is not directed to the House because they cannot be stopped from exercising their constitutional duties. But the order is directed to the Speaker, which is an integral part of a constitutional process of removing a governor under Section 188 sub 5. So the governor, the CJ has been restrained, and in a democracy like ours, rule of law must triumph not only in our legal system, but in our body politics. Parties to a litigation must accept decision of the court, order of the court in good faith, subject only to pre-processes available in law. And no party should employ self-help to disparage or disrespect the order of the court.
Thank you.
It must be respected.
Dr. Amadi, this whole thing now, the CJ has been restricted by a court injunction, but there has to be a solution, and the court injunction is just for 7 days. In thinking or preferring a solution, what do you think can be done? Would the lawmakers want to retreat and find a common ground?
The problem with this politically is that it's a zero-sum game. Zero-sum means somebody just wins, somebody just loses. And loss, Wike has articulated it as in loss is like capital punishment. So the solution is very simple. I think that is on both sides there are issues. So the governor is not dealing with the House in good faith and can't, because the House itself is not dealing with the governor in good faith, and that's the problem. Now, the good faith would be that the Governor General or self-elect Governor Wike, who is going around openly saying, I brought this guy, I made a mistake, I must bring somebody who will protect me. So clearly, the crisis here is not a crisis about constitutional breach which can be remedied and the governor can promise not to breach them. It's a question of ownership. The Wike wants to own this government, feels he has a moral, ethical right to own it, falls back on assumed resettlement by the president, whose enforcement would be decapitate the governor. And the governor doesn't want that. And the governor is fighting, and it's maximalist. The governor says the only way to survive, go for a second term, or whatever everybody does, is to throw away Wike's ownership of me. So solution then is someone has to accept, and I've said before on many occasions, that Governor Wike has to accept that in this politics, Nigerian politics, and by the way, there's a script with Tinubu who has kept Lagos. So Wike is want to keep Port Harcourt in that sense. So, but unfortunately, the play of power is different. Unfortunately, his leverage is different from Tinubu, who has succeeded in keeping Lagos himself in a significant way. Unfortunately, Wike cannot keep Port Harcourt, it looks like. And the result is this attrition that you're seeing. It's just politics. And law, as usual, will be a handmaid of politics.
All right, thank you so much. Thank you. Dr. Sam Amadi, Executive Director, Abuja School of Social and Political Thought. Thank you for coming in this evening. And here in our studio, we had Vincent Otakupu, legal practitioner. Thank you once again for coming in. Thank you.